Welcome to Rock Center Shorts. I'm Kristen Savell, Executive Director at the Rock Center for Corporate Governance at Stanford. I am very pleased to introduce today's guest speaker, Aisling O'Shea, who is a partner at Sullivan and Cromwell. Aisling is co-head of the firm's FCPA and Anti-Corruption Group and a member of the Criminal Defense and Investigations Group and the Litigation Group. She serves as National Co-Chair of the American Bar Association's White Collar Crime Committee and has been recognized for her work by Global Investigations Review, Who's Who Legal, Chambers Global, and Chambers USA. Prior to rejoining the firm in 2017, Aisling spent more than 5 years as a trial attorney in the FCPA unit of the fraud section of the DOJ's criminal division. Quite a mouthful. Welcome, Aisling.
Thanks, Kristen. Happy to be here.
Happy to have you. Today, we're going to talk about corporate voluntary disclosure policies within the Department of Justice. And in particular, I want to focus on a policy released on February 22nd that applies to all U.S. attorneys' offices across the United States, effective immediately. So, Aisling, to help set the stage and provide some context, can you tell us why the U.S. attorneys' offices decided to release a voluntary disclosure policy now? What was the impetus behind that?
Sure. So by way of background, as I'm sure most people in the audience are aware of, voluntary self-disclosure has been among the principles of federal prosecution for business organizations going back over many iterations of that policy, which is binding on all federal prosecutors in the Department of Justice. In September of last year, the Deputy Attorney General, Lisa Monaco, in both a speech and a memo to federal prosecutors about the department's initiatives for addressing corporate crime, ordered all components of the Department of Justice that have a role in prosecuting corporate crime to come up with their own voluntary self-disclosure policies that would expand on the concepts articulated in the principles of federal prosecution of business organizations to the extent that those components did not already have a voluntary self-disclosure policy.
The Monaco memo, as we colloquially refer to it, outlines some core principles that all department components are required to adhere to in developing their self-disclosure policies. Can you tell us about those principles?
Sure. So she required that each component's voluntary self-disclosure policy explain what constitutes a voluntary self-disclosure, set forth a view on what the required timing of any voluntary self-disclosure must be, and states the need that the voluntary self-disclosure policy be accompanied by principles associated with the timely preservation and collection of relevant documents and evidence, as well as its production to the department, as well as the types of information that would need to be shared at the time of the voluntary self-disclosure. And finally, what benefits that component is willing to provide for companies that voluntarily self-disclose.
Right. So the United States Attorney's offices released a written voluntary disclosure policy in response to the Monaco memo. What about other divisions within the Department of Justice that are responsible for prosecuting corporate crime?
Sure. So prior to the issuance of the Monaco memo, the antitrust division had its leniency policy, which has obviously been a standalone policy in effect for some years. The criminal division had the FCPA corporate enforcement policy that until earlier this year was advisory in other criminal division cases. It is now the criminal division's corporate enforcement policy, so constitutes the criminal division's voluntary self-disclosure policy. The National Security Division had its own voluntary self-disclosure policy. And then subsequent to the issuance of the Monaco memo, and just recently, as you noted, the U.S. Attorney's offices, the Tax Division, and the Environment and Natural Resources Division each issued their own voluntary self-disclosure policies.
Great. I want to spend a little time walking through the U.S. Attorney's Office's voluntary disclosure policy. And to start things off, perhaps you can explain how the policy defines a voluntary disclosure.
Sure. So I think one real commonality among the various components policies, as well as the way voluntary self-disclosures are articulated in the Justice Manual and the Principles of Federal Prosecution of Business Organizations, are a number of common themes. And these themes are also reflected in the sentencing guidelines chapter on defining voluntary self-disclosures for corporations. So specifically the U.S. Attorney's Office policy says that the voluntary self-disclosure has to be prior to an imminent threat of disclosure, which is to say you can't have a whistleblower or a journalist or someone saying, I'm going to publicize this tomorrow unless you tell someone about it today. It needs to be prior to the conduct being in fact publicly disclosed or otherwise known to the government. It needs to be reasonably prompt. Reasonably prompt is not defined, but it is defined that the burden is on the company to demonstrate its promptness.
Mhm.
And there needs to be no pre-existing obligation by operation of a regulatory obligation to disclose, a contractual obligation to disclose, or a prior DOJ resolution. I think most corporate resolutions with the Department of Justice impose ongoing disclosure policies throughout the term of probation or a deferred prosecution agreement or a non-prosecution agreement.
Okay, that is very helpful. Now, what are the benefits that accrue to companies that voluntarily self-disclose to a U.S. Attorney's Office?
So there is a presumption against a guilty plea, except in a situation of certain aggravating factors, which we'll discuss. And even then, the policy says a guilty plea is not automatic. Companies are just not entitled to a presumption. There is the possibility of no criminal penalty, and in any event, a penalty that is no less than, a 50% reduction from the otherwise applicable sentencing guidelines range. And there is potentially a reduction of up to 75% off the applicable sentencing guidelines range. And then if by the time of the resolution, the company has both implemented and tested an effective compliance program, there will be no imposition of an independent compliance monitor.
All right, so in the wake of the Monaco memo, there appear to be 6, if I have that right, voluntary disclosure policies governing different components of the Department of Justice. Are these policies consistent, or are there material differences between them? And if there are differences, Aisling, can you share some of the more notable discrepancies?
Sure. So as I said, generally, they're fairly consistent in defining what constitutes voluntary disclosure, what the timing needs to be, the requirements to preserve, collect and produce documents, and the type of information that you would need to share. There are different presumptions about what benefit you would get from a voluntary self-disclosure. In the antitrust policy, it's complete leniency. In the criminal division policy, it's a presumption of declination of prosecution. In the national security division policy, it's a presumption of a non-prosecution agreement. And in the U.S. Attorney's Office, the tax division, and the ENRD policies, it's a presumption of no guilty plea. So in terms of the potential benefits, what that presumption is really varies fairly widely from policy to policy. In addition, each component has defined the aggravating factors that might take one out of that presumption of a declination of an NPA against a guilty plea and define them fairly differently. I think there are some common themes, but some key differences. So in the criminal division, the aggravating factors include a significant profit to the company, the egregiousness or pervasiveness of the offense within the company, criminal recidivism, and the involvement of management in the offense. The national security division policy, I think, is more focused in certain ways because the aggravating factors include the export of particularly sensitive items or to end users that present heightened concerns. Again, recidivism or repeated violations, the involvement of senior management or a significant profit. The U.S. Attorney's Office policy is a little bit narrower. Conduct that poses a grave threat to national security, public health, or the environment is deeply pervasive throughout the company or involved current executive management of the company, which is a key distinction. And then the tax division policy also includes involvement of executive management. It doesn't have that current modifier as none of the others do. The pervasive or long-standing conduct, prior criminal recidivism, and also civil tax findings by the IRS that were either related to or similar to, which I think is a fairly broad category, the current offense. And then ENRD, it includes the threat of or serious adverse impact to the environment, public health and safety, things that result in the loss or endangerment of human life, wildlife, et cetera. So that one, like the National Security Division one, has a set of fairly tailored factors.
Great. So I'm curious where you think the U.S. Attorney's Office's policy fits within these other policies in terms of it being more or less favorable to companies.
So I think that all depends. And of course, what ends up being a more or less favorable policy will all remain to be seen when we have an opportunity to look at the outcome of resolutions pursuant to that policy. I think that because the criminal division policy began its life many years ago as the FCPA pilot program, which then turned into the FCPA corporate enforcement policy. And I know you and your team keep extensive track about the data while those have been in effect. We don't really know what resolutions have resulted from any of these new policies that were just announced. So I think it's clear that the presumption of a declination of prosecution is more favorable to companies that self-disclose, fully cooperate, and fully remediate than the presumption against a guilty plea. But on the other hand, the aggravating factors in the U.S. Attorney's Office policy are narrower than the aggravating factors set forth in some of the other components policies.
There are a number of circumstances in which a company may be jointly investigated and prosecuted by a U.S. Attorney's Office and by another office within the Department of Justice. As you well know, that happens all the time in FCPA cases. If those offices have different voluntary disclosure policies, then which policy will apply?
So I think there are going to be some easy questions and some less easy questions that we're going to have to stay tuned to see the answers of. So you cited the example of an FCPA case. What is now the criminal division corporate enforcement policy is codified in the Justice Manual as being binding in all FCPA cases nationwide. So I think it's clear that in an FCPA case, it would be that policy that would govern. In an antitrust case, I think the antitrust division's leniency policy would clearly govern. I think more broadly, as we get into areas that don't relate to a specific component's exclusive jurisdiction or expertise, it will remain to be seen which policy governs. I should note that the U.S. Attorney's Office policy does call for consultation with other relevant components and, if necessary, approval from other relevant components. So I think what we will probably end up seeing, even where it's not explicit which policy would apply, is that if there is a component with subject matter expertise over the offense at issue, so for example, the tax division, ENRD, then their policy is more likely to apply than the U.S. Attorney's Office policy. And in other cases, it will be a matter of consultation among the components.
Do you feel like we are in a place where companies that uncover misconduct are going to engage in a type of forum shopping and pick and choose whether to report to a U.S. Attorney's Office or to the criminal division or the tax division, depending on the elements of the voluntary disclosure policy that the DOJ component has in place? And if so, how should companies approach that decision?
So I think people may try. I think I would urge that, especially because all of the components policies urge the timeliness of voluntary self-disclosures, and these decisions are very much made on the clock. And so we highlighted a few minutes ago the potential differences in aggravating factors among the various components policies. You don't necessarily know at the time that you're faced with a self-disclosure decision which, if any, of those aggravating factors may apply that may take you into an aggravating factor in one component's policy that isn't an aggravating factor in another component's policy. So you may be left ex ante with only the differences in incentives. So I think it would be very difficult to game out. And as I said, because components that have particular jurisdiction or expertise in a given subject matter, for example, FCPA, tax offenses, environmental offenses, antitrust offenses. I think people that are trying to make these decisions on behalf of companies should be thinking, practically speaking, about what's an appropriate nexus between whatever conduct you're contemplating self-disclosing and who are the right people to call in the Department of Justice, because I think that an overt attempt at forum shopping of calling one component about a matter that is clearly more appropriately before another component, at least atmospherically, will affect the department's views about the good faith nature of the voluntary self-disclosure.
All right, last question, Ashley. The U.S. Attorney's Office's voluntary disclosure policy states, and I'm quoting here, crediting voluntary self-disclosure of misconduct by companies helps to incentivize self-reporting and ensure individual accountability for misconduct, end quote. In your experience, is that true? In other words, do these policies actually do what they are intended to do?
Again, I think it's really too fresh with respect to any of these newer policies. To be sure, I think there is no question that the department is trying in good faith to provide broader and more explicit incentives for voluntary self-disclosure. As I said, voluntary self-disclosure has been a factor in the principles of federal prosecution of business organizations for quite some time, and I think it's become clear through the speeches and the memo issued by Dag Monaco that she thinks that the department can and should do more to emphasize and incentivize voluntary self-disclosures. I think looking at the data in FCPA cases over several years, one doesn't see, and I think you've looked at this pretty closely, what appears to be a dramatic uptick based on publicly available information. But because the only publicly available information relates to cases that have actually been brought or resulted in declinations under the policy, we don't necessarily know how many voluntary self-disclosures there were when the department decided at the end of the day that there wasn't an offense worth either bringing a case or bringing a corporate enforcement policy declination with respect to. And so I think it's an unknowable to the public question at every case that this might influence corporate behavior, but it is very clear that the department is very much trying to influence corporate behavior in favor of voluntary self-disclosures.
Well, it will be interesting to see how all of this plays out. Thank you so much for your time today, Aisling. I really appreciate you being here.
Thanks so much, Kristen.
And thanks to everyone in the audience for joining us. I hope you all have a great day.